Hello and welcome to Inside Judicial Watch. I'm your host, Amelia Kane, and I'm sitting down with Ramona Kotka, one of our senior attorneys. Ramona, thank you so much for being here.
Thank you for having me.
Judicial Watch has been in federal court fighting the battle over Hillary Clinton's emails. We have had several victories, one being a federal judge granting significant new discovery in the Clinton email case. What was the State Department trying to argue during this hearing? And I'm sure our viewers are eager to know what exactly happened.
Sure. Well, we've heard the question being asked before in the context of Benghazi, what difference does it make? And that question did not bode well for Secretary Clinton. And that is the same pretty much position that the State Department had at the hearing that we, in front of Judge Lamberth on August 22nd, I guess almost 2 months ago now. The State Department, well, at that hearing, Judicial Watch had requested additional discovery in light of new evidence that was uncovered in the first round of discovery that Judge Lamberth granted us in this Freedom of Information Act case. In response to our request, the State Department took the position, there's nothing here, nothing to be seen. And by the way, Judge, there won't be any recovery that Judicial Watch can get in this case either. Judge Lamberth disagreed with the State Department's position and granted us almost all of the discovery that we requested. He granted us 7 of the 9 depositions that we asked for, 4 document requests, as well as 3 interrogatories, which are just in the legal world, they're written questions to witnesses or to parties. The 2 depositions that he had not granted us at the hearing relate to Secretary Clinton and Cheryl Mills.
What was the end result of Judicial Watch's request for the depositions of Cheryl Mills and Secretary Clinton?
Judge Lamberth had granted Secretary Clinton as well as Cheryl Mills 30 days to respond to Judicial Watch's request. Their attorneys appeared at the hearing, and then Judge Lamberth provided us 10 days to file our reply in support for their depositions. Our reply was filed last Thursday, so at this point we are waiting for Judge Lamberth to rule on this, and we expect that the judge will rule shortly because the discovery that he did grant in this round is supposed to be complete by December 13.
Now, it was funny because Judge Lamberth told you to shake the tree. Is that correct?
Yes, he did. Now, that was in relation to additional information that had come up just a few days before the hearing by Senator Grassley's committee that dealt with Paul Gambetta and creation of another email account where it appeared that all of Secretary Clinton's emails were saved on that email account. That is also something that we are looking at in the discovery, and we are working on that as well.
Very interesting. Mm-hmm. The court forced the release of the Clinton WikiLeaks discussion email that confirmed that the State Department knew about her email account. This is very disturbing. Before we dive in, I'm sure our viewers want to know, can you give us some background on what led up to this email exchange and the players involved?
Sure. In the first round of discovery, we deposed John Hackett, who was at the time, in 2013, he was the deputy director of IPS, which basically was in charge of the entire FOIA program at the State Department. 2014, when we had filed our FOIA request, Mr. Hackett became the acting director of IPS. So he was an executive, high-level official at the State Department dealing with FOIA. Mr. Hackett testified at his deposition that in answering our question as to when and whether Secretary Clinton's emails became an issue in responding to FOIA requests, Mr. Hackett testified that in 2013 they had already begun looking at all of the FOIA requests dealing with Secretary Clinton's emails and also begun an investigation into Secretary Clinton's email use. Part of his testimony is that in December of 2013, he wasn't quite sure, January of 2014, this is before our FOIA request, he had reviewed an email in connection with a totally different FOIA request pertaining to email communications between Secretary Clinton and Sidney Blumenthal, which was submitted by Gawker, that he had reviewed in connection with that FOIA request an email exchange that revealed Secretary Clinton's email account. And also there was some discussion about, and this was within Public Affairs Bureau within the State Department, and some discussion about somebody saying, hey, you're not supposed to, be careful, you're not supposed to use that email, or words to that effect. So that is, we asked in this discovery that email that Mr. Hackett referred to in his testimony, and Judge Lamberth agreed with us that that's important here, right? Because it shows that the State Department was on notice that there was a system of records that included Secretary Clinton's emails that should be looked at, or should have been looked at, in response to FOIA requests pertaining to her emails, which obviously our case does. And the State Department initially, after our document request, pursuant to Judge Lamberth's order, said they don't have anything. And then what you call in the legal world is meet and confer, where the parties get together and they say, look, clearly we've described what Mr. Hackett, the State Department was taking a very narrow read of the document request that that we had requested of them. And we said, look, we're going to go to the court if you don't interpret this as obviously was described by Mr. Hackett. And I believe within the next day or so anyway, shortly thereafter, the State Department produced the email that Mr. Hackett was referring to. So
Judicial Watch was fighting back?
Yes.
Yeah.
Yes. And we were going to go back to the court. And I think the State Department realized Judge Lamberth would not look favorably on State Department's actions in the way that it was processing this document request that Judge Lamberth had granted us. So anyway, so they produced it, and for the first time, Judicial Watch, they produced an unredacted version of this email. And the significance of this, and sorry if I'm getting ahead, but I just want to note the significance of this is twofold. One is, the email is from 2010 with high-level State Department officials from Public Affairs. The significance, the first part of it is high-level State Department officials knew Secretary Clinton was using personal email, but also knew that they're not supposed to forward it, and that, I quote from the email, where Mr. Baer writes to Michael Posner, be careful, you just gave the Secretary's personal email to a bunch of folks. And then Michael Posner responds to Daniel Baer, should I just say don't forward, did not notice. And then Mr. Baer responds back, yeah, I just know that she guards it pretty closely. The second part of the relevance to our case is the fact that one of the executive officials within the FOIA department at the State Department knew of this email, knew that Secretary Clinton had an email account that she guarded pretty closely before we even filed our FOIA request. And yet when the State Department returned and responded to our FOIA request, they hadn't bothered to look for Secretary Clinton's emails in response, and they hadn't bothered to tell Judicial Watch that there were emails that they hadn't reviewed, that Secretary Clinton had used email for State Department business.
This is government corruption at its finest, isn't it, Ramona?
Well, it's not good. And the thing is, we just the more we keep digging, the more we keep going, the more we're finding. Thing about litigation is great because it provides us the tools to gather this evidence and the information. However, it's a slow-moving process. So it's one piece at a time. And the only other thing I want to mention about these documents, if I may.
Of course.
So if you can see here, this is the document that State Department produced to us in unredacted form. In 2016, the State Department produced the same document, but in redacted version, if you can see here, on its website, and this is at the time that all the investigations were going on into Secretary Clinton's emails and before the elections. The B5 over here signifies the basis for the redaction. B5 in the Freedom of Information Act world is typical. It can be for attorney-client or work product, which clearly doesn't apply here, but deliberative process. And that privilege is basically intended to protect communications that are interagency or intra-agency, where officials are communicating about agency policy.
Mm-hmm.
Nothing, now that we've seen this document in unredacted version, nothing here shows inter-policy or interagency deliberations about State Department policy.
What you're saying is the same email we received was published some time ago. That's what you're saying?
Yes, but in redacted form. And so they admitted that they had an email, but they redacted all the significant information from there with respect to how State Department officials treated Secretary Clinton's emails and also how the Secretary herself treated and intended for her email to be treated at the State Department.
Very disturbing. Now, going forward, a federal judge criticized the state and Justice Departments on the Clinton email cover-up. What do you think influenced the judge's decision that was so compelling?
I think the State Department's position that there's nothing here when clearly there has been so much evidence that has been discovered in the first round of discovery. I think it's the repeated, I don't know if I want to say failures, but by the State Department to really not be candid with the court. Obviously, our case claims that there's bad faith by the State Department for not disclosing Secretary Clinton's emails when they processed and when they attempted to settle this lawsuit with Judicial Watch. Since then, the State Department has, and as of just the most recent hearing in August, State Department's position is nothing is new here, and whatever is new that's been discovered is of no significance. Well, just to summarize, and I'm only going to summarize just a few points of what new information we learned in the first round of discovery, which took place between January through June of earlier this year. In 2013, Mr. Hackett and his department and his superior had issued a directive to FOIA officials not to send any further what is called a no records located response to requesters who asked for under FOIA for records pertaining to Secretary Clinton's emails. In the summer of 2013, the State Department was conducting an investigation into the use of her email account. We have this email that Mr. Hackett testified to about in December of 13, January of 14. In August of 2014, what we've uncovered is that Mr. Hackett was warned by the attorney, and by the way, the attorney who actually processed our FOIA request and who we will be deposing, I believe in November next month. He warned Mr. Hackett that in August, around August of 14, that there may be publicity for the State Department with respect to Secretary Clinton's email use. This is in August of 2014. In November of 2014 is when the State Department had responded to Judicial Watch. We've searched everything, and these are the only 4 documents you have. Obviously, we know on December 5th, State Department received 12 banker boxes of Secretary Clinton's emails. In December, on the same date, State Department also gave us what is called a draft Vaughn Index, which basically is an explanation of the basis for any documents or information that they're withholding or redacting from the documents they gave us. That was all done in an attempt to settle with Judicial Watch. And by settling, meaning we've given you everything you asked for, Judicial Watch, now agree to dismiss the case. This is all very compelling, and Judge Lamberth found the new evidence that we discovered compelling and the basis for the need to have the additional discovery that we requested. And hopefully we will get to actually ask Secretary Clinton herself, did she guard her email very closely? And why did the high-level State Department officials respond the way they did? And also, we have questions of Ms. Mills that we would like to ask.
Mm-hmm. Now, my final question for you, Ramona. You've been so informative. Thank you. What is next for Judicial Watch in the Hillary Clinton litigation saga?
Well, the discovery continues. We actually have a deposition this Friday. So we've already taken 1 of 7 depositions. We have the one on Friday and then the remaining. And we're waiting for Judge Lamberth to rule with respect to the depositions we asked of Secretary Clinton and Ms. Mills. We'll see if we need to go back to the court and ask for anything else, or what the evidence shows at the end of the discovery. But all of this needs to be done and concluded by December 13, pursuant to the court's order.
Judicial Watch is not giving up.
No.
Nope. Well, thank you, Ramona, and thank you for covering what the mainstream media is not covering.
Sure.
And thank you for tuning into Inside Judicial Watch. If you liked our video, please visit our website, donate to our work, and find us on Facebook, Instagram, Twitter, and YouTube. Thank you.